Oh boy, is it Monday again already? I guess it is. I guess that means it's time for another episode of Monday Morning with Mo. Happy Monday, everybody. These things Mondays just keep coming at you, don't they? Hope everyone had a great weekend. It was a cold weekend, but hopefully it should be warming up today. And hopefully you got one of the St. Patrick's Day silicone pints or silly pints that we were giving away last week. If you didn't, make sure that you subscribe to our texting service. It's 407 698 3984. It's 407 698 3984. And all you have to do is text that number. It'll send you an autoresponder back. Just go through that, and that gives us the permission to text you, basically. We won't spam you. We never spam you. But when we do promotions like that, the texting service gets it first. So if we do giveaways, or if we're doing events, we always send it to the texting service first. And then it is me. It's only me who has access to that. So you're not going to get like random texts or solicitations or anything like that. You'll just get good information. And then of course, if you ever need something, you can always text me back. It goes right to here into my cell phone. So you can get a hold of me if you need me. So if it's your first time joining us, this is Monday Morning with Mo. I am attorney Mo DeWitt, and we meet you here every Monday morning on Facebook and YouTube to answer your legal questions every Monday at 8 a.m. So that's what we're here for. So let's dive into it. We got a few voicemails to start us off. So let's go to the voicemail line. Oh, by the way, I didn't cover that. So voicemail line. If you have questions, leave us a voicemail number down here below, 407-536-6737. I know I'm throwing a lot of numbers at you this morning. Or email us, askask@dewittlaw.com, and we'll shoot you an email back, and we'll read your question live on the show here. So let's go over the voicemail line and see what we got.
Hey, Mo. Hey, Chris. Mo, hope your mom's well. I had a question about homeowners insurance. If a tree branch or a tree should fall on your property, unexpectedly, wind, storm, whatever, and say it hits a car in a driveway, does the homeowner insurance cover that? Let's say it's a visitor's car, and maybe they don't have car insurance. You know what I'm saying? Is the homeowner's insurance responsible for something of that nature? Very much appreciated. This is Sean in Scottsmore. Thank you.
All right, thanks for the voicemail, Sean. Not sure where Scottsmore is, but maybe I'll look it up after the show here. So short answer is yes. If a tree falls, smashes a car, homeowners insurance will step in and pay for that. But here's kind of the caveat with Florida law. So usually the questions we get are not if it's on, let's say you have a guest over, a visitor over, one of your trees falls on their car, smashes it. Usually that's pretty straightforward. The homeowner's insurance steps in, pays for the car repairs. Excuse me. Where it gets a little more complicated is where a tree falls onto the neighbor's property. That's usually the question we get. And so under Florida law, it's basically the health of the tree that determines who is responsible. So, excuse me, sorry about that. So if the tree is healthy, falls on the neighbor's property, then whatever portion falls on the neighbor's property, they're responsible for that. If there's a portion that falls on your property, you're responsible for that. So basically, wherever the tree lands, whoever's property is responsible for it. However, if a dead tree falls on the neighbor's property, and the person who owned the tree, so to speak, if the tree was on your property, and you had noticed that the tree was dead and it falls and causes damage, you are responsible for it. And so, it's basically to encourage people that have dead trees to get them removed, because you'll be responsible for it. If it falls on your neighbor's house, if it falls on your neighbor and kills them, you would still be responsible for that. There's actually been some pretty interesting cases where people have, in a lot of cities, you have to get a permit to remove a tree, over 5 inches in diameter or something like that. And so the homeowners have applied for a permit to the city to have the tree removed because it was dead. the city said no, then the tree fell and caused damage. And then there was a lawsuit against the city for them to pay for it, since essentially they were on notice that the tree was dead and prevented the homeowner from removing it. So there is some interesting situations, interesting case law that's arisen from kind of tree fall cases. But yeah, essentially, if it lands on your property, it's a healthy tree. No one knew it was dead. You're responsible. If someone knew it was dead, then they can be responsible for it. So the other key there is, if there's a tree that's dead that you want removed, send a letter to whoever's property the tree is on to put them on notice that the tree's dead and could cause damage, because then if it does, you have the letter to prove that they were on notice for it. So great question there, Sean. I appreciate it. If you guys have questions, leave us a voicemail, 407-536-6737. Thank you, as always, for joining us this morning. I know no better way to start your Monday than getting some legal advice, answering some legal questions here. You can also drop them in the comments below. Sometimes I have a trouble, I always have trouble actually typing to respond to the comments while we're doing the show, because I can't multitask like that. But still put them in there. At the very least, I'll respond to them after the show and talk about them on the next show probably. So anyways, we got another voicemail here. Let's go to that one. So
thank you. This is Doug from DeLand, Florida. I was just curious as to the distinction between a trust, a living trust, and a will. And if you could make that real simple at some point, I think myself and other people would be very appreciative of that as we get a little bit longer in the tooth. Thank you so much.
And Doug from DeLand's got a great radio voice there. All right, so will versus a trust. So pretty simple. A will lays out your wishes after you die. So basically, when you do a will, it says, hey, this is what I want to happen when I die. A trust becomes effective immediately. So basically, a trust is, while you're alive, you're fully in charge of your trust. And basically, when you become incapacitated or die, the person you appoint as a successor trustee can then step in easily to handle your affairs, as you prescribe them in the document. So that's kind of the difference, and as probably as much of layman terms as I can make it. Excuse me. Now, most people will probably recommend that you have a will and a trust. And there's a reason for that, is because basically you can dictate what happens after you die, as well as lay out some things to have your affairs handled while you are still living, and then easily transition some of those things after you pass away. So most people, it always depends on your situation. You got to talk to an estate planning attorney and see what kind of assets you have and what's in your best interest. But typically, I think most estate planning attorneys would recommend, if you have any sort of significant assets, that you have both a will and a trust. Again, it depends on the situation, but I think that's probably the recommendation in most of the cases. But yeah, will lays out your plans after you die. Trust goes into effect immediately. And then the successor trustee carries out your wishes basically after you pass away. It's supposed to be a little easier. Trusts are typically designed to kind of help avoid probate. I don't know that there's ever really a foolproof way to avoid probate, but it's basically to hopefully avoid a lot of the legal headaches that probate can cause. So great question there, Doug, and keep the voicemails coming. I always appreciate it. Doug's got a great voice there, and if you have a great voice too, give us a call. Even if you don't, we'll still answer your question. All right, next up here, we have Elaine. Elaine says, I'm thinking about getting a divorce. Am I allowed to open my own checking account and put part of my income in that account while I'm still married? Short answer is yes. You can pretty much do whatever you want while you're still married. Now, when the divorce comes about, you will have to disclose that account. So it's not like the money is no longer marital just because you're putting in an account that's in your name. I guess I should clarify that. So that's a big misconception is, hey, if I have an account that's just in my name or a credit card that's just in my name, that's non-marital money or non-marital debt. That's not true. So anything that's acquired during the marriage is split 50-50, whether it's an asset or a liability. So sure, you can open your own checking account, shove some money away in there. That's still marital money, and you'll still have to disclose it as part of the divorce. But if you feel more comfortable, if you need kind of a safety fund, you can certainly do that. The other thing to keep in mind is, once the divorce is filed, most counties nowadays have what we call an administrative order. And that administrative order is essentially going to say that however the bills were getting paid before, they need to continue to get paid in that manner. So if your plan is to kind of put money away and not pay the bills, that may not work out real well for you either. So short answer is yes. There's probably some more details you need to know there. Not sure how much benefit there is in doing that, but again, some people may feel more comfortable having a safety fund there, having a little bit of control, or having some money, in case of emergencies. So sure, you can certainly do that. Get a little hydration there. All right. So yeah, thank you for the question, Elaine. If you guys have questions, shoot us an email, ask at DeWittLaw.com. Almost forgot the email address there. Ask@DeWittLaw.com or 407-536-6737. And we'll go ahead and answer them there. So last up here this morning, we have Cedric. Cedric says, "Hi, my name is Cedric." Cedric, nice to meet you. I just had a quick question for you. How can I go about giving up my parental rights? All right, so that's a little more complicated than most people think it is. So typically, kind of in general in Florida, you can't really give up your parental rights unless the child's going to be adopted, unless there's a pending adoption. A parent can request that the court grant sole custody to the other parent, but that's not going to get them out of child support, which is usually what people are trying to do if they're giving up their parental rights, at least from what I've seen. It's a pretty serious thing to give up your parental rights, so really make sure you think about it, consult with an attorney, know the consequences of it. It's usually pretty permanent, so you really want to make sure that you're thinking clearly and really put some thought into that decision. Excuse me. The other way parental rights can be terminated is in connection with a dependency proceeding. If the child's in danger, the parents abandon the child, or if the parent's going to be away from the child for the majority of the child's life due to incarceration, those kinds of things. That's a way where the court can also step in and terminate the parental rights. So typically courts don't really let you just voluntarily say, "Hey, I don't want my parental rights anymore. Here you go." There usually does have to be some sort of reason, or the child has to have a pending adoption. So that's it for this morning. Hope you guys have a great week, great Monday, great Tuesday, Wednesday, Thursday, Friday, and we'll see you back here next Monday for another episode of Monday Morning with, I can't even say the name of the show anymore. It's going to be a rough Monday. Another episode of Monday Morning with Mo. Have a great Monday, everybody. Take care.